Overseer is presiding.
May be seated. Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Judge. Good afternoon. We're here in the matter of State of Indiana in the relation of the Honorable Sonia Morris, Judge of the Chicago City Court, versus Gilda Orange et al. 45 CO1 1302 PL 1312. We will proceed.
Yes, Judge.
We're here on defendant's motion to dismiss.
Yes, Your Honor. Attorney Stephen Bauer, on behalf of the individual counsel persons who have been sued, as well as the legal entity of the common council of the city of Chicago. Judge, in December, Judge Morris filed a mandamus suit against the common council of the city of Chicago. She is the duly elected and presiding judge in the Chicago City Court. In her complaint, she specifically mentions that this action was filed and mentions trial rule 60.5. And that is the dispute that we have, Judge. The legal issue is, does 60.5 control the proceedings here, or should it be ignored and we proceed as if 60.5 has little or no relevance to this particular litigation? Judge, what triggered this is that the City of East Chicago Common Council, over the last 3 years with the tax freeze, as well as with the 1-2-3% circuit breaker limitation, along with the claim gaming revenues, has substantially reduced its approved budget each year because funds simply were not available. There have been departments that have been shut down, etc. The long and the short, Judge, to bring it to the point, is that when it came to budget time, there were almost across-the-board reductions in all of the budget, as well as including public safety, as well as the clerks, and the council opted to do about an $80,000 to $83,000 reduction in the court's submitted budget by Judge Morris. This triggered, this action by the council and the reduction triggered the mandate. Judge 60.5 was very interesting. I'm sure that I really don't think that Your Honors have to be involved in one of these. They are very rare. But one of the major issues that we've got here today is that on behalf of the Common Council, we have moved to dismiss this separate suit for mandate, claiming that we should be proceeding under 60.5. 60.5 contemplates that the judge, himself or herself, issued the mandate. And when that happens, then the Supreme Court is notified, and then an attorney who does not practice in that court and who is at least 2 counties away is appointed to be the hearing officer and to listen to the presentation of evidence and to issue a judgment or ruling on the allocation of funds. That's the procedure here I suggest that's specifically called for in 60.5. The rub is that in one of Gary's fights in the 1980s, that involve Chuck Braddock, a case ended up before the Indiana Supreme Court in which there was language in the case that specifically said, well, we're not going to apply 60.5 to city courts or to municipalities. The problem is, Judge, is that the Indiana Supreme Court in 60.5 specifically says whenever a court, except the Supreme Court or the Court of Appeals, desires to order either a municipality, a political subdivision state, or an officer either to appropriate and pay unappropriated funds for the operation of the court, In other words, in 60.5, as it currently stands, is the specific comment about judges in a municipality. That would be a Maryville Town Court judge, Cherryville Town Court judge, Corporate City Court judge, or a Chicago City Court judge. Municipality, Judge, I would submit to you clearly, includes towns and cities. So, what we have is a 1986 decision that says, well, this shouldn't be applied to municipalities. But we have two subsequent modifications of Trial Rule 60.5 in which they still leave in there the reference to municipalities. So, the city's argument is that the proper way for this...
Was the rule amended?
The rule was amended December 21st, 2001. Again, amended and effective February 4th, 2009. But I do not know specifically what those amendments were, but I do not think that it directly addressed the language that's in the original rule that talks about municipality.
Was that in the rule in 86?
Judge, I do not know. I've not been able to, when I read that opinion, it did not quote the rule. It just made a reference to it.
And the 86 case is the only case that addresses the issue? There's no case subsequent to 1986?
That's correct. To my knowledge, Judge. I was unable to find one that addressed it afterwards. So a difficulty is, now almost 30 years later, we've got a rule that specifically talks about that it's applicable to municipalities, courts in municipalities, and we simply think, the council's legal position is, we need an independent outside practicing attorney to be appointed. And this was recently done, done about 2 or 3 years ago. The juvenile court judge out of South Bend issued a mandate because they were taking away his vehicles to bring the children from the juvenile lockup to the court and all kinds of things. In that particular instance, he issued the mandate. But once again, Judge, that's not a municipal court. It was a superior court. And of course, Bill Satterley was appointed a hearing officer and did the whole thing and went up to the Indiana Supreme Court. So it is confusing. Our argument is, when they've addressed the modification of 60.5 2 times since the 1986 decision and left into it the reference to municipalities, it's a stretch to ask the court now to simply ignore the specific language that's in the rule. I will not dispute Mr. Schmall's position that the 1986 language in that decision talked about that, talked about that 60.5 wasn't applicable. But once again, what we have, and may I simply conclude by pointing out that Judge Moore's in her own complaint has made the allegation that is being brought under trial rule 60.5. Judge, that's all that I have.
All right, Mr. Small.
Thank you, Your Honor. Please support, for purposes of the record, my name is John Schwall, and I have the privilege of representing the Honorable Sonia Morris, the duly elected judge of the East Chicago City Court. Contrary to what Mr. Bauer has stated, the City of East Chicago has sufficient funds to fund the operation of the court as Judge Morris sees fit. She's not asking for anything extravagant. It's just a question that the mayor has made a decision that he is not going to allocate funds for the council to spend regarding operation of the court. And especially now with the income tax coming, the idea that the City of East Chicago doesn't have enough money to properly operate the court is without merit. The way the court's operation has been affected, the police chief unilaterally took away security officers from the court. They cut the funding of the court. The court has met with the council and has attempted to compromise on an agreed budget. But the council took the attitude that they were going to adopt a percentage across-the-board reduction in her budget, and that was what the judge was told. So I don't think any of this has anything to do with what Mr. Bauer is contending in his motion to dismiss, but since he's mentioned that the city can't afford a court, I certainly dispute that, and I believe the financial records of the city will show that. The city can afford to fund the court. Now, Your Honor's question about Rule 60.5 is a question I ask myself when I look into this. And as I point out in my response to the motion to dismiss, Rule 60.5 was adopted by the Indiana Supreme Court in 1976. And I have attached as an exhibit or copy to my brief, Rule 60.5 as it presently exists, and then as indicated in Harvey's Indiana practice. And then when you look at page 367 and 368, you can see the historical changes in the rule over the years. So in 1976, when the rule was adopted, the rule was exactly as it was interpreted by the Supreme Court in 1986 when it decided Judge Braddock's case. And I believe that when you look at the decision, a unanimous decision of the Indiana Supreme Court, you can see that the court has clearly indicated that a judge of the city court does not have authority to file a mandamus against the city council, and then have the Supreme Court appoint someone to hear that mandamus action. And it's clear from the decision in the Mandate of Funds versus City of Gary, 489 Northeast 2nd, 511, that case law before 60.5 demonstrated that the path followed previously by courts of limited and inferior jurisdiction has been to exercise the basic authority by the filing of an independent action for mandate against the proper municipal authorities in a trial court of general jurisdiction. So before 60.5 went into effect, the proper procedure was to file a mandate in a court of general jurisdiction. So what happened then was that in 1985, Judge Braddock and Mayor Hatcher were in an argument over the proper funding for the Gary City Court. And Judge Braddock issued a mandate to the city, and Judge McLaughlin heard the mandate and gave us action. The Supreme Court clearly held that because of the nature of a city court or municipal court, that it's a court of which handles smaller cases, and that its judgments are subject to immediate review by appeal to the trial court. We're going to treat city courts differently than other courts, regardless of what the rule says. And Judge DeBrewer, speaking for a unanimous court, talks about the characteristics of a city court, and then goes on to state, quote, "We find that the avenue previously followed via the filing of an independent action in a circuit or superior court provides adequate protection for the financial support and independence of city courts, and hold that such avenue must be followed by them." It's not a permissive thing, it must be followed. So we did exactly what a unanimous decision of the Indiana Supreme Court told us to do. In response to that, Mr. Bauer says, or the City Council says, I apologize for saying Mr. Bauer says, the City Council says, well, this is a 1986 case, and the rule has been amended 2 or 3 times since 1986. And in each of those amendments, the court has left stand the exact same language as was present before 1986 regarding what courts the rule applies to. Mr. Bauer says, the City Council says that by reenacting Trial Rule 60.5 and amending it over the years without changing the prior language constitutes an acquiescence by the court in having its rule apply to municipal courts. And in support of that, Mr. Bauer cites 2 cases about legislative acquiescence. But I believe that the council misunderstands the nature of legislative acquiescence. The nature of legislative acquiescence is that if the court interprets a statute, and then the legislature doesn't do anything to amend that part of the statute which the court has interpreted, the legislature has acquiesced in the court's interpretation. So the doctrine of legislative acquiescence supports the petitioner's position. It does not support the relator's position. Now, I think the case that brings it home most to me, and one which all of us who do civil trial work are familiar with, is the long-standing string of cases from both the Court of Appeals and the Supreme Court saying that punitive damages are not recoverable under the general wrongful death statute. And attorneys for dead plaintiffs who are killed by some egregious misconduct on the part of a defendant are constantly asking for punitive damages in these wrongful death cases. And a few years ago, specifically in 2001, the Indiana Supreme Court decided the case of Durham versus U-Haul at 745 Northeast 2nd, 755. That's 745 Northeast 2nd, 755. And in the argument, the court addresses the plaintiff's contention that punitive damages should be recoverable under the Wrongful Death Act. And the court, that is the Indiana Supreme Court, goes on to cite prior decisions which held that punitive damages were not recoverable under the Wrongful Death Act. The court then went on to state, when it, meaning the legislature, disagrees with judicial rulings, the legislature can act. And then specifically about the changes in the Wrongful Death Act over the years, the court went on to state in its holding, quote, failure to address punitive damages cannot be attributed to legislative indifference to the wrongful death statute. The legislature has amended the wrongful death statute approximately once a decade since the 1930s. But despite these many other changes to the Act, the legislature has never amended it to address explicitly the availability of punitive damages. We can only conclude that the legislature is content with the consistent line of cases finding punitive damages unavailable. So, applying that logic to this case, we know that the Supreme Court of Indiana, in the Braddock case, in 1986, held that 60.5 does not apply to municipal courts or city courts. We know, based upon the history of the rule, as I pointed out in my brief, that there have been changes in the rule, modifications to the rule by the Supreme Court since that time. But never has the Supreme Court done anything with the language which it had previously interpreted. That language remains the same, despite those changes, which took place in 1985 and 2001. So it's Judge Morris's position that an independent action for mandamus filed in either a superior court or a circuit court, a court of general jurisdiction in the county, is the proper vehicle for her dispute with the East Chicago City Council. If Mr. Bauer believes that my reference to Rule 60.5 is inappropriate in my complaint, then I believe that should be stricken. But Rule 60.5 says it applies. The decision says it doesn't. I believe 60.5 sets a framework for decision making, but it's not controlling in this case. We go back to the same rules that had been present before the Braddock case. And Your Honor has the power to do this. Your Honor is an experienced judge of both a city court and an experienced judge on this court, and can certainly hear the evidence and make a decision regarding Judge Morris' request for adequate funding for the court, and hear the testimony regarding the financial condition of the city of East Chicago and what money they have available and what uses they are putting that money to determine whether her requests for funding are appropriate under the circumstances. We would ask that the court deny the Common Council's motion to dismiss, and that the court set this matter for a hearing. The reason I say that, at the present time, the court was operating under the budget that it wants to operate under, which it believes is necessary. There is money for that budget probably until November. So come November, there's not going to be sufficient funding for the court to continue operation.
Judge, very briefly, the 2001 amendment that became effective April the 1st, 2002, specifically required for the appointment of an attorney 2 counties away who does not practice in the court to serve as the hearing officer. Judge, I strongly suggest that that's extremely relevant to identify and disclose the intent of the Indiana Supreme Court in having an independent, quite frankly, non-judicial person to decide the issue of court funding. That became effective in 2002, and on that basis alone, the fact that the rule was not changed to delete a reference to municipalities suggests just the opposite of the position taken by the Judge's Council. This is not legislative essence. You have a specific situation in which clear, unequivocal language in the rule is not removed. It is left there. If they contemplated simply filing a suit in the local superior or circuit court in order to litigate the mandamus issues, why would 60.5 then talk about appointing an attorney for 2 counties away who does not practice in that particular court? Judge, may I suggest, the reason for that is there was no appearance favoritism or what happened. They wanted to make sure that the person hearing this was not involved in any way, either in the operation of the court or the politics existing within the community. So that's where we are, Judge. Thank you.
I have one comment here. I believe that the position that Judge Morris has taken in this case, or I've taken on her behalf in this case, is exactly the same position as Judge Harkin took when he was having his dispute with the City Council of Hammond, and Judge Devine was the one who heard the dispute.
When was that? Was that before these amendments, or?
Judge Devine's dispute was within the last 4 or 5 years. Excuse me, Judge Harkin's dispute was within the last 4 or 5 years.
All right, gentlemen, let me review it. I've heard your arguments. I'll issue a decision shortly.
Thank you.